I'm delighted to welcome everyone to the program today. My name is Sarah Flannery. I'm a partner in Thompson Hine's Immigration Practice Group. I would like to welcome you to today's webinar. This is the first in a series of webinars examining what the shift in presidential power could mean for the country. Before we begin, a few details about the program. Today's program is being recorded and we will send a link to you within the next few days. This presentation is intended for the general information of individuals and organizations on matters of current interest. The thoughts and opinions expressed today are those of the individual panel members only and do not necessarily reflect the opinion of the panel members' clients, employers, affiliates, or Thompson Hine. The content should not be taken as advice, as the views expressed here are for informational purposes only. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen. We will answer as many of the questions as we can at the end of the webinar. In the handout panel, you can also download a copy of the PowerPoint slides and bios of today's speakers. Again, thank you for your interest, and if you have questions as we go along, please use the question box. I am delighted to introduce my co-presenters today, Kelly Hayes and Dwight Meifel. Both are members of the firm's Immigration Practice Group. All three of us have focused our practices exclusively on employment immigration. We advise clients on sponsorship, securing work visas and green cards for employees, and we advise clients on compliance and worksite investigations. That side of our practice is the focus today. Today, we will cover what can be expected with increased worksite enforcement during the Trump administration. What is the impact it has on M&A considerations? What is the impact it has on risk assessments of current compliance practices? We will dig into two types of worksite enforcement, audits and raids. And we will also discuss steps to mitigate employee loss. The best predictor of future behavior is past behavior. In 2017, during President-elect Trump's first administration, we saw the largest fine imposed on a company for hiring unauthorized workers. Thomas Homan, who has been named the Border Czar with responsibility for all deportations during Trump's second administration, was with ICE during the first administration. When he was with ICE during that administration, he called for worksite enforcement to increase fivefold. It did increase fourfold in 2018 and 2019. Those worksite raids have been down significantly under the Biden administration. In October 2021, the Biden administration issued a memo establishing an end to mass worksite enforcement operations. What we have largely seen during the Biden administration is a workplace enforcement action only when it is triggered by an allegation of wrongdoing, and usually that wrongdoing is paired with not only the allegation of unauthorized workers, but some other mistreatment of those workers, poor work conditions, safety violations, or wage and hour violations. Based on the actions of the prior Trump administration and statements made by President Trump, we do expect to see worksite enforcement increase in the administration. So what will be the impact? Short-term considerations are companies should prepare for I-9 audits. We will discuss this a little bit more in detail throughout the webinar, but you can conduct internal audits and complete cleanup now in preparation for a worksite investigation. Companies can prepare for possible worksite raids, establish policies for how to respond, including consideration of what public communication would look like. Employers should also prepare for loss of workers, perhaps, and that may not necessarily be through a worksite investigation, but individuals who are present in the US without work authorization may be subject to deportation, separate and apart from a worksite investigation. What are some long-term considerations? The focus of our webinar here is going to be on worksite enforcement, and so I'm going to start with the bottom two in the chart here. Companies should strategize for how the change in policy may impact valuation of companies that are in industries with high rates of unauthorized workers. Those industries would include construction, food processing, agriculture, landscaping, hourly manufacturing work. The value attached to a company in a high-risk industry may be skewed if there is not an accurate assessment of the legitimacy of the work authorization of staff. For instance, if a company were to buy a subsidiary entity and 10% of that subsidiary had to be separated 6 months post-acquisition because of an I-9 audit or a raid, how does that impact the business value? If a company acquired a subsidiary in a target industry during the more complacent environment of the last few years, but looks to sell in the higher scrutiny environment, purchasers may want a greater confidence in the legitimacy of the work authorization of the staff. Now, our long-term considerations can lead to what can we do to better ensure a lawful workforce. You can consider implementing best practices to minimize the risk of unauthorized workers. Enrolling in E-Verify. E-Verify is a federal program. It is not mandated across the country by the federal government. Certain states do require it, but not all. Companies that are in states where it is not mandated may want to consider enrolling in it. Employees who are responsible for I-9 completion can undergo training to exercise greater scrutiny when completing the I-9 and evaluating the documents given by the employees to verify identity and work authorization. Companies can schedule regular internal audits. Not all of the concern needs to be employees without work authorization. This top long-term consideration point is related to individuals that are fully authorized to work in the US right now, the dreamers under DACA, and individuals from certain countries who have temporary protected status. Those individuals have full work authorization right now, but a long-term consideration for employers who have high concentrations of employees with DACA or TPS is to get your arms around how many people in our staff hold that type of work authorization, because the Trump administration has stated at times that it would consider trying to roll back those bases of work authorization. And in the first administration, they did try to roll back those work authorizations. So it would be helpful for companies to also consider, who do we have that is currently authorized but might lose that authorization going forward. Now that we've set the stage with the short-term considerations and long-term considerations, we're going to dig deeper into the two different types of worksite enforcement that we're going to discuss today, I-9 compliance and worksite raids. I'm going to turn it over to Kelly Hayes to pick up with the I-9 audits.
Thanks, Sarah. So to set the stage before I get into sort of the nitty-gritty with audits, as a refresher, an I-9 is required for every employer. Every employee has to fill it out. This concept came about with the passage of IRCA in 1986, and what IRCA mandates is that all employers, regardless of size, have to verify an employee's identity, and they also have to verify the employee's authorization to work. So the employee accepts their offer, and then as part of your onboarding documents, they receive the I-9 that they have to complete and provide documents to verify those two things. Section 1, which the employee is responsible for, has to be done on their first day of employment, and then the employer has to inspect those documents, the originals, and complete Section 2 by the 3rd day of employment. It has to be maintained for the duration of employment and for a certain period after termination or separation from the company. And how you maintain these I-9s should be consistent for all employees, whether that's paper forms, storing electronically, and if you choose to maintain the documents that you also inspected or copies of those documents, then that should be consistent across all employees as well. Next slide, please. So why should you care? I think the most obvious reason is penalties. So an I-9 seems like a pretty no-brainer concept. I suspect everyone that's joining the call today has probably done one of these themselves, or maybe you're the person tasked with doing this for your company. And we consistently hear from clients that they are fairly confident in their I-9s. But Sarah, Dwight, and myself, we do routinely examine these either as from a request from a client to clean them up or as part of due diligence during a merger or acquisition. I think the record that I have gone through before finding a mistake on an I-9 was 3. So even with a high level of confidence, the errors are just so easy to make. They just exist on a lot of forms. As an example, earlier this year, just a few months ago, I did due diligence as part of an acquisition. It was a small target company. They have 43 employees. And of those 43 I-9s I reviewed, only 9 were absolutely correct with no mistakes. So that was about an 80% error rate. So if the government tags that employer, let's say they do audit them, they find the same error rate, if they tag them with a single paperwork violation per form at the highest penalty up there on the top line, $27.89, then that employer is looking at about $100,000 worth of exposure. How they get to that ultimate fine is a little bit more complex than just a simple, one error equals one fine. They look at a variety of things to either enhance or reduce that fine. But the point is the fines are real. As an example of a real life one that I just read about, this particular company had 50 employees, I believe. Failed to produce 6 of them, 6 I-9s. Either they were never done, lost, doesn't matter. The government hit them with a $65,000 fine. So depending on your business circumstances, a fine may not necessarily be your biggest concern. You may be able to absorb that without, maybe it's a small fine, $10,000, and you might be able to absorb that with not a lot of sweat off your back. But some of the other considerations are, if you find that you have employees without authorization to work, you're likely going to lose those employees in fairly short order. And you might make the news for whatever the circumstances are, which is not great. Either way, an audit is a disruption to your business. So I'll get into this a little bit more, but basically you've got 72 hours to turn everything over. And so tagging someone with this responsibility of getting everything together, getting it over to the government, and then dealing with anything subsequent to that takes away from their normal day-to-day business activities. It's not enough to necessarily just go through the motions of simply doing an I-9. You really need to train your people on how to inspect those documents, what they're looking for. You might think everything was done correctly, the form appears to be filled out, all looks good, you turn it over, and then the government comes back to you and says, hey, every single green card that your person reviewed, turns out it was a fraudulent green card. So again, the fines may not be the biggest thing. It's the employee loss that you're going to have to deal with. And then as Sarah mentioned, if you are thinking about selling or you're ripe for being acquired, you always have this purchase price in mind of what you think the value of the company is. But if a buyer comes in and finds out that they're probably going to lose a substantial portion of the workforce, then they're going to want to reduce that purchase price. As another example, I worked with a buyer, and they were able to put pressure on the seller to reduce reduce the purchase price, and then they put the seller on the hook for using a staffing agency to mitigate employee loss while they work to make permanent hires. So to this particular seller, that was significantly worse than a theoretical audit that never did materialize. So the reason we think this is going to be a big deal, fines aside, is that Trump campaigned heavily on immigration. And then, as Sarah mentioned, we've already seen this once. So in 2017, Trump issued an executive order called Buy American, Hire American. And with that order, he directed ICE and other agencies to use resources to step up enforcement action. So this here is a quote by ICE in 2018, where they essentially bragged about the number of investigations that, quote, surged in the first year of this administration. So by surge, we mean we saw about a 430% increase from the last year that Obama was in office. And then the following year after that, it was 30% on top of that. And then we did anticipate that to continue to increase, but that was the year of COVID, or that COVID started. So then that obviously changed all priorities. So the point being, if the playbook is already written, we think it's an easy thing for the incoming administration to essentially pick up where they left off. And they've already put people into place that know exactly how to increase enforcement efforts. And again, this makes for very good headlines. If they want to get you, they can, and then they can make a headline out of it and sort of show that they're making good on those promises during the campaign to step up enforcement. So you've probably assessed by now that I'm suggesting that everyone walk away from this webinar with a task, which is to pull a handful of I-9s yourself or direct your compliance person to do so. And I promise you'll probably find mistakes. The errors, again, are just incredibly common and easy to make. Some examples are maybe your HR personnel printed a handful of I-9s, stuck them in a drawer to easily pull out on day one of employment, didn't realize that the edition had changed, and therefore they're using an expired edition. I often find that employees forget to sign, they forget to date, they forget to check in the box of how they're authorized to work. Similarly, employers, they forget to sign, they forget to date, they forget to re-verify work authorization. And then common as well is there's a variety of documentation that someone can show you to show their work authorization. It's tied to immigration status. It's difficult to know exactly what you're looking at all times. And so employers will simply record with their best guess of what type of work authorization they're looking at, and they record it incorrectly. So again, every single one of these technically is a finable offense. Again, the government can enhance or reduce those fines. And one way to get a reduction in fines is to perform a self-audit, as that's looked at as a mitigating factor. Another reason to perform a self-audit is, again, you may have workers that you reasonably suspect may not have work authorization. And quite frankly, the time to figure that out is now. It's not when the government arrives and they figure it out for you. So we've been approached by clients that think that they have maybe 10% of their workforce working without authorization. So setting aside an ICE raid, which Dwight will get into here shortly, if an investigation reveals at a time that you're not expecting, which you have absolutely no control over, you're going to lose those employees pretty quickly. And ICE may not be so receptive to a gradual reduction in workforce if they don't feel that you've done everything that you can to reduce those workers, or to do the right thing. To make sure that your workers have authorization. So again, a 10% reduction in workforce undoubtedly is going to disrupt your business operations. So a self-audit can help mitigate that drop. You can work with counsel to figure out ahead of time, where do we need to clean up? What do we need to do? What is our situation? And then you have a reasonable period of time to clean that up. So reasonableness depends on the circumstances very much so. So counsel can help you work through those circumstances so that way you can show that you are in fact complying with the law, but in a non-discriminatory way. So a notice of inspection arrives. You have essentially 72 hours to turn everything over, all 9 I-9s, your employee roster, and then any supporting documents. So you want to make copies of everything that you turn over. You are essentially the target of an investigation now. So you want to know exactly what you just turned over. Having an idea of what you turned over is going to be helpful on the back end, as you have to negotiate whatever the government then replies with. I recommend involving counsel then, because maybe some things can be corrected in short order. You find an I-9 where the employee forgot to sign, or something fairly simple that's easy to clean up, and mea culpa, it was just an honest mistake, but everything is fine with that particular employee. So again, copy everything, work with counsel before you turn it over. The government's going to review those fairly quickly, and then they're going to issue their results. So they can do a variety of things, ranging from a compliance letter to issuing a fine. So a compliance letter basically says, yes, you've done everything correct. We find no material violations for which you're subject to a fine. Or they issue the notice of intent to fine, which I think is probably more likely to happen during the incoming administration. Next slide, please. So you receive this notice of intent to fine. What the government is doing is saying they've reviewed the documents. They have their allegations. They have their legal basis of how they got there. They have their attachments, which are the facts that underlie those allegations. And then the gist of the document is, it is the intent of ICE to order you to pay $200,000. You do have the right to contest. So you file a written request before an administrative law judge within 30 days. ICE will generally respond to you inviting a settlement agreement, which, depending on the circumstances, you may want to go forward with. And I haven't seen a situation yet where it wasn't in the client's best interest to negotiate. So maybe ICE made an error in how they arrived at their particular fine amount. Maybe they failed to consider a variety of mitigating circumstances, like your good faith, self-audits, internal trainings, recently signed up for E-Verify. And you also want to point out how this fine is likely to hurt your business. So again, some employers can absorb it with relative ease. Others, $10, $15, $20,000, that's not so easily absorbed, or you don't necessarily have that cash on hand to fork over to the government. So again, essential to have immigration counsel negotiating this for you, because then the counsel can also pull for you and help as part of this negotiation similar circumstances where in the past the government was more lenient, did reduce those fines. And then finally, if you do nothing, the final order is issued in 45 days and the employer is subject to that fine. So with that, I will turn it over to Dwight to talk about raids.
The ICE raids, that's where the action is. So let's kind of talk about how they work. The first thing, though, that we have to do before we go any further is we have to talk about who in the world is ICE. And I'll begin by saying who ICE is not. ICE is not ISIS. Kelly and I were talking to someone the other day, and he kept calling them ISIS. When ISIS comes to do a raid on your business, and I wasn't entirely sure whether he was confused about who he was talking about or whether he was just being sarcastic, but it made me laugh. This is what you need to know. ISIS is a terrorist organization, and ICE, capital I, period C, period E, is not a terrorist organization. ICE actually stands for U.S. Immigration and Customs Enforcement. And ICE is part of a bigger umbrella of the Department of Homeland Security. Generally, when we talk about the Department of Homeland Security, we're talking about USCIS, which is the agency that processes visa applications, and CBP, which are the people at the border that ask you questions about why you're coming to the US. And then there's ICE, and the three of them together are generally responsible for the US immigration system. ICE essentially are the people that are responsible for enforcing violations of US immigration law. So you can kind of basically think of them as the immigration cops. They're the people who come and pick you up if you're going to be deported. And they are also the people who conduct raids on US employers to arrest anyone who's working illegally. So what is an ICE raid? So an ICE raid is when ICE agents go to an employer's worksite without warning as part of an investigation, and they're there for a couple of reasons. Either they know specifically that someone works there that's in the US illegally, or they're just going to do a survey of, they've gotten some kind of tip, they believe there's a problem with the workforce, or it's just kind of an employer that typically has a lot of unauthorized employees. And so they're going to go and they're going to check, they're going to go verify people's employment and then detain anyone who's not supposed to be working. They show up unannounced. They start going through your team, verifying the employment authorization for your employees, and then they will arrest and take away anyone who's not supposed to be there. So back to the idea of drama and why employers enjoy ICE raids so much more than they enjoy I-9 audits. When the government wants to conduct an I-9 audit, they actually send you a notice ahead of time, and then they give you time to respond. And I mean, seriously, what's the fun in that, right? There's no guns, there's no black Suburbans. You can have your attorney there, you can have your attorney help you respond, and they tell you ahead of time that they're coming. That's all kind of boring. ICE doesn't do that. That's why ICE raids are so much more exciting. They just show up, they don't tell you they're coming ahead of time. When they get there, you can't ask them to wait to come in until you've called your attorney and got your attorney to show up. They go in, they show up, and they get started right in on what they're gonna do. I don't know if there's anyone on this call who hasn't seen the Will Ferrell movie Elf, but I think for me, the best personification of ICE is think of them as the Central Park Rangers. They come thundering in on their horses and they wreak havoc everywhere they go. So then the next question we get asked a lot is, who's going to get raided? And the answer is, we don't specifically know, but we have some good guesses. Sarah kind of already referenced them. We think it would be construction, food processing plants, restaurants, nurseries, the nurseries for trees, not the nurseries for babies, agricultural, landscaping, places where they know there are going to be a lot of illegal workers. They're probably not going to raid a large tech company in Silicon Valley because they're probably not going to find 200 people working there illegally. But they might find that in a big food processing plant. And a big splashy raid where you get to arrest a couple of hundred people and have video of them being taken out, you know, in handcuffs and put in vans and taken away, that makes for big headlines, which totally serves the narrative that the incoming administration has been laying out during the election and since the election was over. They will go after the big tech companies, but they're going to do that with I-9 audits where they're looking for paperwork violations. That they're not going to go in a tech company and get a big sexy raid where they get, you know, a whole bunch of people that are working illegally. So if you are in one of those areas where we know, for example, the Pew Institute in a recent survey said that they believe at least a minimum of 15% of all workers in the construction industry are working illegally. The government knows that, they've seen those numbers, and those are the kinds of industries that they're going to start in, at least coming right out of the box in January and February. So how can an employer be prepared for an ICE visit? Well, the first thing you want to do is you want to retain counsel ahead of time. You do not want to be trying to look up an attorney in the phone book while ICE is banging on your front door. And once you've retained an attorney, the things you want to talk to them are how many employees do you think don't have authorization? What issues do you have at your work site? What's a plan for how you're going to respond when ICE comes knocking on your door? You're going to work with them to get your documentation in order, and you're going to try and get as far ahead of this issue as you can before ICE actually knocks on your door. The second thing is you want to formalize a plan for how you're going to respond when they actually walk up to your door and walk in. And then you want to train your employees on that. You want to make sure that your employees understand that they are not allowed under any circumstances to grant ICE access to your business. Only you can do that. You don't want your receptionist, you don't want an ICE agent walking up to your receptionist or whoever is the first person they would greet when they walk into your business and have that and say, hey, we're ICE and we want to see your records and we want to talk to your people. And you don't want that person to then lead them down the hall to your HR office, walk in, open all the filing cabinets and say, here you go, let me know what else you need. Because when they do that, you've then given permission to ICE to look through all your records, and they're probably going to be looking through stuff they're not even allowed to be looking through. But once you let them in, you can't argue, well, they never should have been in there. So you need to have your team know that they don't have permission to let ICE agents into the business. You're the only person that can do that. So the next question is, where can they go when they show up? So when they walk into a business, they're allowed to go into any public area that anybody else would be able to go to. They can go to parking lots, they can go to the lobby, they can go to the waiting area. If you're a restaurant, they can go to the dining area. If you're a store, they can go wandering the aisles. What they can't do though is, even if they're allowed to be in that area, they can't kind of basically set up they can't block the doors and not let anybody in or not let anybody out of public areas until they've been questioned and demonstrated their employment authorization. There are limitations with regard to what they can do. So if they come in and they start doing that, just going through, your restaurant, going up to every table and asking somebody, what's your legal authorization? You immediately want to go talk to them and you say, hey, I need to talk to a supervisor. You're not allowed to do this in a public area, and I'm not going to consent to you doing this. And the idea of consent is something, it's very important. We're going to talk about it more in a second, but it is important that you articulate to them you do not agree with what they're doing. When it comes to private areas, they can only enter a private area in one of two areas, or in one of two ways. Either, first of all, they have your permission, which we've already agreed you're not going to give them, or the second is they have a judicial warrant that allows them to get into that area. So what you want to do is, in order to make it clear what are your public and private areas of your business, you want to make sure that you've put up signs that say private. You want to keep the doors closed, you want to keep them locked, and you want to have a policy that says visitors just can't randomly wander into those areas. So ICE then doesn't have the ability to argue that they're a public area because they're clearly marked. So how can you then tell what ICE is allowed to do when they're in your business? And the answer is, look at the warrant. It's all going to be in the warrant. So a judicial, there are two types of warrants that they're going to have. And the first type of warrant is an administrative warrant. It's not issued by a court. It's not signed by a judge. It just says to an ICE officer, go arrest this person. They're here illegally. That warrant, an administrative warrant, doesn't give them permission to enter any private areas. The only warrant that lets them do that's a judicial warrant that's issued by a court, has to be signed by a judge. When they come in, you want to say, do you have a warrant? I would like to see it. Make sure that it is a warrant issued by a judge, and then it's going to tell you what they can and can't do. It's going to tell you when they can be there. It's going to tell you what they can take, if they can take your business records, it's going to outline it. And you want to read the warrant, keep a copy of it if they will let you, and then follow them to make sure that they are not doing anything that exceeds what's been laid out for them on the warrant. Now, here are some things that are really, really important to understand. Number one, asking to see a warrant doesn't mean that you are actually giving consent to them doing what the warrant says they can do. Just seeing the warrant and reading it, and some officers will say, well, look, you asked for the warrant, you got the warrant, now you've given us permission to do whatever it says. No, that doesn't mean that. The second thing is you can refuse to give consent. That's not going to stop them. But at least it's important that you make it clear you're not agreeing, volunteering, letting them do what they want to do. That could become incredibly important later if they've exceeded the bounds of their authority when you argue, hey, they had no right to take that stuff. So you want to verbalize to them, I'm not agreeing with this. I'm not agreeing to let you take that record. And looking at the warrant alone doesn't translate to consent. The third thing, and this is incredibly important, is you can't stop them. Don't try to stop them. Don't try to carry your records out the back door in a box. Don't try to physically block them from going anywhere. You need to tell them you're not agreeing to do what they want to do, because you never want them to come and say, well, you agreed to everything, but don't make any effort to stop them. I tell my kids all the time, if you're driving down the road and you get stopped by a police officer and the officer tells you to get out of the car, get out of the car. Maybe they don't have a legal basis to stop you. Maybe they don't have a legal basis to ask you to get out of the car, but they have a gun and you don't. And so when they tell you to get out of the car, get out of the car. If an ICE officer walks into your office and says, I'm taking this box of your records, you should say to them, I don't agree. I'm not agreeing for you to take those records, but do not try to stop them. They have guns, you don't. Getting in a fight with an ICE agent is never going to end well for you. All right, so during the raid, what should you be doing? First of all, you need to remain calm because your employees are gonna take your lead. And if you are panicking and freaking out, then they're going to think that that also is something that they maybe need to do. Make sure you tell them. You should tell this ahead of time, but tell them not to run. Running is bad. Running gets people hurt. Also, running makes them look like they're really guilty. Just tell everybody we're going to remain calm. We're going to get through this. We're not going to get anybody, that ends up getting thrown on the floor and cuffed because they're being a problem with the officer. Number two, everybody has the right to remain silent. I like to say that there are some people who have the right to remain silent, but they don't have the ability to remain silent. And I would beg you to seriously consider whether or not you should be talking to the ICE. Don't help them. Even if you think that's going to make things easier for yourself down the road, it's not. It doesn't matter how nice they're being to you. Don't help them. I had a client one time that said to me, "I'm not stupid. I didn't fall for their good cop routine." Don't fall for their good cop routine. It's just going to get you nowhere. You don't have to point out people that are working illegally, even if you know who they are. And frankly, you should not, for this reason. You can be criminally charged for knowingly employing people who are working illegally. And the last thing in the world you want to do is say to an officer, if they say to you, "Well, look, it'll be easier if you tell us who's working illegally, and then we'll just go get them and leave the rest of your people alone." You then telling them that is acknowledging that you know who's working illegally, which means it's an admission that you're knowingly employing people who are working illegally, and that can and will be used against you in a court of law. The Biden administration did not aggressively pursue criminal actions against employers, but Trump did in the first administration, and we have every reason to believe that that policy is going to be renewed, if not escalated, with the incoming administration. The third thing to remember during the raid is that your employees, if they're not free to go, they have a right to have an attorney. But these are things that you want to explain to them in meetings before ICE ever shows up as part of your training plan. You don't want to be standing there shouting at them not to talk to ICE while ICE is standing right there trying to talk to them. That's going to be a problem. You should have all of this explained to them ahead of time so that they understand. And then the last thing is call your attorney. Have your attorney's name and phone number in your cell phone so that you can just whip it out and get in touch with them right away. They might be able to talk to a supervisor on the phone during the raid. ICE isn't going to wait for them, but there's a good chance that at least you'll be able to have them interact some, and ICE will certainly know that you're serious about making sure that they only do what they're allowed to do and not anything more than that. So the final slide is steps to mitigate risk of loss of employees. And again, I was trying to be funny when I said that employers preferred ICE raids to I-9 audits. There's no employer that's ever preferred an ICE raid to an I-9 audit. They're not fun, they're not funny, and actually they're pretty terrifying. But the key is this: you want to start, we know they're coming, and if you're in an industry that's particularly vulnerable or is going to be a good target for the government, you want to get out in front of this as early as you can. And that means talking to counsel, identifying exactly how bad your problems are, identifying exactly how bad your I-9 files are. Here's something to kind of pick up on what Kelly had said, which is that some employers, they think, oh, well, an I-9 audit's not that bad. The worst thing that could ever possibly happen is I get a fine, which I can pay. And they're kind of almost lackadaisical in the response to the I-9 audit. But you want to be extremely diligent about having those records in order and then responding properly to those, because every I-9 audit breeds the possibility of an ICE raid if it turns out that in the course of the I-9 audits, they see you have a lot of unauthorized employees, that you're like basically sending a love letter to ICE that says, hey, please come visit us. So you want to be super serious about your responses to your I-9 files. And then when you're getting ready to prepare for the possibility of an ICE raid, you also want to make sure that you have all of those records as accurate and as correct as possible. An interesting thing about I-9 files is you don't have to keep them for eternity. There's a fixed amount of time after someone's employment is terminated of when you can destroy them. And you certainly should meet with counsel and talk about an appropriate document destruction policy so that you don't have files lying around that just further substantiate ICE's allegation that you are an employer that has no regard for the rules, which is kind of the tone of voice that they're going to use. So you definitely want to talk to counsel. The second thing is you are going to definitely want to, now that we know enforcement's going to be ramped up, you maybe want to be a little more stringent in your hiring practices, and you definitely want to increase training for your staff so that you are getting the cleanest I-9 documents you can possibly get, that you're having the fewest unauthorized workers that you can possibly have, and then you can also look at the possibility of using E-Verify. I really hate to say this, but E-Verify is a really good program, and it works really well, and it's free, and I never like to say anything about that the government does well, but that actually is a really good program. And one of the great things about it is if you run somebody through it and the program comes back and says they're authorized to be employed, as long as you've properly verified the document and make sure the photo on the document you submit matches them, and then you have a safe haven. So E-Verify could be certainly something that you look at implementing. And then if you're in an industry with a high level turnover, you're going to want to sit down with your team and say, what in the world are we going to do if we have an ICE raid and they walk in and they walk out the door with 20% of our staff? What can we do now, whether it's engaging with staffing companies, whether it's, considering alternative staffing options, so that you do not have your entire business come to a total and complete grinding halt when you lose a significant number of employees. So, it's kind of funny. We've gone 4 years now where we just really have not talked about I-9 audits and ICE raids very much, but they are back, and it is definitely something that needs to be on your radar, and it's definitely something that, so you've got basically the rest of December and then 20 days in January before we start to get a real idea of how quickly they're going to come out of the box on this. But my personal opinion is that I would not be surprised if within 10 days of the inauguration, we don't see a big article about a number of raids and wholesale arrests of people that are working unlawfully, and you don't want to be one of the people that is in that headline. All right, back to Sarah.
Thanks, Dwight. One thing that I will add on the steps to mitigate risk of loss is that there are ways for individuals that have subject matter expertise, such as immigration lawyers, to be able to look at documents that employees have presented as evidence of work authorization and identify those that look invalid on their face. That level of expertise might not be expected of an HR individual, a supervisor who is doing hiring, and it might not lead to there being any fines against the company for failing to detect those fraudulent documents. But you still would face the loss of those employees who are without work authorization. So by engaging a subject matter expert to come in and look at the documents, one, you can get an understanding of which ones do look invalid on their face and mitigate for that. And then you can also do training for those individuals with the company who have responsibility for I-9 compliance to be able to implement something closer towards that higher level of scrutiny going forward through training. We are now going to move towards questions that we have. A question here is, can employers sponsor workers who are currently without authorization for a green card? There's no one size fits all answer, but usually for someone who is currently without authorization, without legal status, there's not going to be a clear path forward towards a green card, even if the employer would be willing to make that investment, because the general rule would be that in order to change status, you have to be in lawful status. Another question, if we use an HRIS system like ADP or Workday, doesn't that ensure that the I-9s are correct? Kelly, would you mind tackling that one?
Sure. So not necessarily. Using a vendor can be a good idea, and particularly if you have a large employee population where those records have to be maintained. But time and time again, we hear what I would call horror stories of the person who's in charge of that compliance program moved on, no idea where those records were stored, moved to a different vendor, all the records are lost, can't be accessed. So merely using a vendor doesn't ensure that you can produce those documents in a timely manner. You still need to have complete control over the compliance program. And then second, human errors simply happen. For example, it is a violation or a technical violation to spell the employee's name wrong. So something like that, very simple, it's a typo, nobody caught it, that is technically a violation. So just simply relying on a vendor to say, you know, you're in charge of this isn't necessarily going to get you out of all scenarios where something could go wrong and you'd be tagged with a penalty.
Next question. For staffing companies, if there is an ICE raid at one of the client sites, will the raid be specific to the client, or would the staffing company's employees also be part of the raid? I anticipate that the scope of the raid would be dependent on the scope of the warrant. I can confirm that when there is an I-9 audit and inspection, not only will the request ask for documents of employees, but it will also ask for any contractors to the company. So if a client site is the target of an I-9 audit, they're going to be asking that client, who are the vendors that you use for staffing? And then that can also expand the scope of the investigation. Kelly or Dwight, do you have anything additional to add to that?
I think the only thing that I would add is also if they're there talking to all the principal employers, employees, you know that they're going to end up asking questions of the contractors or the staffing company's employees. And if any of those people in some way, shape, or form communicate to ICE that they don't have employment authorization, that staffing company is being pulled in, you know, just as a practical matter, even if they weren't targeted when ICE showed up.
As I go into the next question, I will reiterate, because I know we had some people join after the intro comments were made, that if you do have a question, please use the question box located in the control panel on the right side of the screen and send it through there, and we will try to answer as many as we can. Next question here is, what are the expectations with the processing of work visas? So this goes more towards the sponsorship side as opposed to the worksite enforcement, and what should employers expect in terms of being able to secure work visas for employees, whether those are the seasonal work visas or the H-1Bs. What we saw in the first administration was a higher level of scrutiny, meaning that you would submit a petition that historically was maybe a slam dunk approval, and the Immigration Service would issue a request for additional evidence saying, we're not sure that this is approvable. You need to give us more documentation for it. I don't have an expectation of expanding work visas, but there has been some discussion of that. The President-elect Trump did say that he would consider expanding the number of green cards that could be issued to foreign national graduates of U.S. universities, for instance. But we don't, all that we can point to from the prior administration was there were higher levels of scrutiny. Another question. Do you recommend companies keep copies of the documents used by employees to complete the I-9? E-Verify does require that certain documents get kept as copies if they are used. If a company is not an E-Verify company, they're subject to the general rule, which is you don't have to keep copies, it's your choice. I do recommend it as a best practice. First, it does allow to correct mistakes that might be on the I-9. So for instance, if you took down the social security number wrong when completing the I-9, but it's attached, that is a correction to it. It also does allow an audit to be completed, and without copies of the documents used to complete an I-9 audit is a very minimal value. You can certainly correct I-9s for mistakes that are on the forms themselves, but you're not going to be able to make a determination around whether or not the documents presented by the employees looked valid on their face.
Sarah, can I add one other thing?
Yes.
So the other thing I would say is if you're going to keep documents, be uniform in it. What you don't want to do is not keep documents for everybody unless something looks a little weird and then you go, oh, well, I better just keep these. You need a uniform policy that says we're going to keep them all or we're not going to keep them all, and then consistently follow that.
Good point. Any other questions to be added here at the end? What is the correct way to correct an I-9 where too much information was collected? So this is when completing an I-9, you either have a list A document, a single document such as a permanent resident card, or a combination of one document from column B, one document from column C. And there shouldn't be too much collected. Kelly, would you mind tackling the question of when doing an audit and you come upon I-9 files where there was a green card, a driver's license, and a social security card, for instance, all attached, how would that be corrected?
So I think best practice is to do a new I-9 form and attach it to the old one and approach the employee again and say, there was a problem with the document collection process. Here is the list. Can you provide to me the documents that you would like to present? I think often untrained personnel overcollect inadvertently because the employee turns everything over, and so they absolve themselves of any problems because the employee voluntarily turned it over. But as we're looking at the forms, maybe that's sure that was the case. They did turn it over voluntarily, but there's no way to know that after the fact. So I always think it's best practice to reapproach the employee. There's ways to do that, to say that this is, this person was not targeted. This is not because there's anything wrong necessarily with them or their work authorization, but that there's an error with the form itself that needs to be corrected, and please help us correct it.
And if you're seeing this with regard to a I-9 file that is within your retention period, but the employee is not with the company anymore, if they gave you a list A document and a list C document, the list C document alone wouldn't suffice. So in that situation, I would just put an X through the social security card, the list C document, remove the social security card from the attachment to the file, and keep the permanent resident card. So there might be a way in which you can correct it on your own because there isn't the opportunity for the employee. We thank all of you for your interest in attending today's webinar. Our webinar series, Transition, a Presidential Change, will continue in January 2025. Sessions will be held on Tuesdays at 2 p.m. Eastern Standard. Check your inbox for invitations on the upcoming topics. We hope that you can join us. If you are not currently receiving our updates and invitations, we invite you to go to the Thompson Hine website and register to receive our mailings under the Publications tab. Thank you for joining us today, and we wish everyone a lovely end to the year. Thank you.